Hi, everyone. Good morning, good afternoon, depending on where you are. Thank you very much for joining us for our first ever Associates Private Client Network event exclusively for our Asian contacts. We really hope that you will enjoy today's panel discussion and that you'll be able to stay and join us afterwards for the networking session, where we'll be split into small groups in breakout rooms for discussion. And just to say that as we go through, if you do have any questions that occur to you while we're speaking, do please feel free to pop those in the chat box as we go along. For those who don't already know me, I'm Patricia, and I'm joined today by my two colleagues, Alfred Liu and Dickon Ceadel. Alfred and I are both international private client lawyers, and we specialise in advising families in Asia on a variety of areas, including family governance, cross-border estate planning, trusts, and UK pre-residence tax and immigration planning. Dickon is a senior associate in our matrimonial team, and he advises on a wide range of family-related issues, including divorce and prenuptial and postnuptial agreements. Our theme for today is next generation issues. And these are very, very relevant to family wealth and business succession planning for many older generations and business founders in Asia. For a lot of families, we're seeing the baton passing to generation 2 and generation 3, but there are often complex cultural interplays at work between the generations in their expectations and understandings, which can complicate intergenerational dialogue. More specifically, we commonly come across two significant events in the lives of next generations that cause most concern for our clients in Asia. And those are the marriages of next generations and next generation children. We thought it would be useful for us to share with you today our thoughts on why considering and addressing these two areas is so critical to achieving successful multi-generational wealth transition. What can be done to address these issues in order to avoid or at least mitigate the inherent risks of wealth dissipation that they pose? And also to give you our perspective on them based on our experiences with families that we've worked with and as next generation advisors ourselves. So let's start by thinking about marriage. Alfred, if I can just bring you in here, what issues do you see in relation to marriage that are more unique or perhaps just different for next generations compared to their predecessors?
Thanks, Patricia, and hello to everyone in attendance. Yeah, I think it's interesting. Compared to parents, it's more common to see next generations in Asia to be in transnational or cross-cultural marriages and civil partnerships. And I think that's because they tend to be more internationally mobile compared to predecessor generations. Millennials and General Z members in particular are more likely to be what we call third culture kids, being either born, raised, educated, or working in the West, for example. So when you combine that with the fact that parts of Asia itself are incredibly multicultural with large expat communities, it's not so surprising then that next generations are more likely to meet, fall in love with, and ultimately marry people outside of their parents' country of origin and culture. But as we know, this can create certain long-term wealth preservation and succession issues for families in the region.
Which the couples themselves obviously never think about at the time that this happens.
Exactly.
Can you give us some examples of legal or indeed other issues that are caused by these transnational cross-cultural marriages and relationships that our audience today should look out for?
Yeah, sure. I mean, I think what we've seen is transnational marriages can actually expose families and family wealth to foreign tax regimes, which they never originally planned for or anticipated. A good example is a married couple we're advising where the wife is Hong Kong Chinese and her husband is a British expat. And they're considering moving to the UK for their children's education for the short term, but ultimately they intend to return to Hong Kong. Many in the audience will be familiar that from a UK inheritance tax perspective, an individual's liability to UK inheritance tax at 40% on death is based on their domicile position, not their residence. So even with British expat, a husband has acquired a Hong Kong domicile of choice, the UK tax system will treat him as being UK domiciled when they moved here. His wife, however, will be firmly non-UK domiciled, so her personal assets outside the UK are not subject to inheritance tax. So what's interesting is that you suddenly get this, what we call a domicile mismatch between the couple. If the wife predeceases the husband, her will currently provides that all of her assets pass to him. This includes her shares in a BVI company that she co-owns with her parents and siblings. And this company holds a pretty high value investment portfolio. So there's a real risk that if the wife predeceases the husband, then her part of her family's wealth held in this BVI company will be dragged into the UK inheritance tax regime when her shareholding passes to her husband's UK domiciled estate. So we're looking at modifying her will and the BVI company structure to avoid this situation.
It's that classic cross-border element that you were talking about.
Exactly. Yeah.
And another common area of concern that we see being voiced by heads of families is in relation to future spouses of next generations benefiting from the family wealth or getting involved with the family business potentially. Can you talk a little more about that?
Yeah, sure. I mean, I think we've all seen it as advisors. Older generations often voice caution about younger generations' future or even current spouses getting their hands on the family wealth. In most cases, it's not personal. Families invariably take a guarded approach to outsiders. So most families generally accept the principle that next generation spouses can benefit in some way from the family wealth or get involved in family business. But they don't want their spouses to do so unfettered. And there's a greater risk of this occurring if next generations personally hold family assets in shares in a family operating business, for example. So appropriate safeguards are required to introduce degrees of control over how next generation spouses can benefit. And a good starting point is structuring wealth in asset holding vehicles like discretionary trusts. We recently helped a Philippine client who's second generation himself, set up a trust in Singapore. And he had this real strong aversion towards his children's future spouses being able to benefit from the trust. His initial preference was to actually make them excluded persons in the trust deed, so they couldn't benefit at all. And we explained that this approach could be too rigid and may actually create problems in the long term, such as breeding resentment from his children if they discovered this. And they could very well do so. As beneficiaries, the children could be entitled to see the trust deed. So as advisors, I mean, we play devil's advocate and raise that to our client that there are circumstances where it may actually be perfectly reasonable and fair for his children's future spouses to benefit from the trust. For example, the spouse is a good spouse, which can be measured in a variety of ways, such as the length of their marriage to his children or the spouse's positive contribution to the wider family. So after this discussion, our client realized that there's actually value in taking a far more flexible approach about the question of whether his children's spouses can benefit. So instead of making them excluded persons in the trust deeds, we actually ended up helping him develop a letter of wishes that clearly set out guidance for the trustees about when his children can be regarded as good spouses and can therefore benefit, and even when they can be treated as bad spouses. And if that is the case, then the trustees can consider whether to make them excluded persons or not at that time. So we managed to achieve an appropriate balance and maximum flexibility for clients. And of course, like speaking of bad spouses, our clients in Asia are increasingly thinking about divorce among next generations and what planning can be done to mitigate against the risks this poses to the wider family wealth. And a growing feature, as you know, Patricia, is planning is the use of nuptial agreements, especially for families in Asia where you have younger members take residence in other jurisdictions like England, where the courts may tend to favour the less affluent spouse in divorces. And we've got Dickon as a matrimonial lawyer. Dickon, you're the expert on nuptial agreements. What are they and how can they be used by families as a tool for protecting family wealth?
Thanks, Alfie, and hello, everyone. Yeah, so all marriages end either on death or divorce, and nuptial agreements are an increasingly popular way in which families and advisors can use them as a wealth planning tool, just as wills and other estate planning measures are used to protect assets on death. So prenuptial agreements are obviously those which are signed just before the marriage, and postnuptial agreements are signed after the marriage. But essentially, they do the same thing, and they are treated exactly the same way by the courts. So, as you probably know, nuptial agreements allow parties to define what is to be shared in the event of a future divorce and in what proportion. But also, crucially, it allows them to define what is not to be shared. And usually, this includes money that they brought into the marriage, and any family money, such as inheritance, they may receive during the marriage, or trust interests. And often we're seeing investors and entrepreneurs entering into agreements as they want to ensure that if their ventures are successful, they're not required to give away half of their assets in the event that they do get divorced in the future. So the agreements we tend to prepare increasingly often these days are bespoke. They can be really, really simple, and it often starts out that people intend them that way. For example, they can just say, in very simple terms, that we want to each leave the marriage with what we brought into it within reason. Or they can be much more complicated, and often where there's a significant disparity in wealth at the beginning, there's a hot negotiation about exactly what the financial provision should be in the event of a divorce. And that can be on a sort of tariff basis, whereby it's usually the wife and the financially weaker party receives an increasing amount depending upon how long the marriage is and whether there are children, for example. So nuptial agreements are not automatically binding in England, at least, but since a significant Supreme Court case about 10 years ago, they are likely to be upheld in the event that they are done properly. I understand that the same principles in the Radmacher Supreme Court case are actually followed in Hong Kong as well. So what does done properly mean? From an English perspective, it means that both parties can be shown to have entered into it with their eyes wide open, so they know what they're signing up to. And in practice, this means that they both had legal advice, or at least had the opportunity to take legal advice. And they've exchanged material financial disclosure of their assets and income positions, but also what they may reasonably foreseeably have in the future. So that would include inheritance prospects and things like that. And the thinking is that both parties should be aware of what claims they're potentially giving up by signing up to the agreement. Usually we say in England that if at all possible, the agreement should be signed at least 28 days before the wedding. It's not fatal if it's not, but the idea is that if it's signed before the wedding, it can be shown that there hopefully wasn't too much duress or undue pressure placed on one of the parties by the invites or already having gone out, the dress having been bought. There'd be excessive embarrassment that would be caused to them, so they feel I have to sign up to whatever this incredibly miserly agreement that's put in front of me is, because otherwise I'm going to have to embarrass my whole family. So if it's all done in good time and it's negotiated properly, then it's quite likely to be upheld in England, so long as the final requirement is met, which is that its terms are broadly fair, and that's determined as at the time of the divorce rather than as at the time of the agreement being signed. And obviously that presents difficulties for us lawyers and for the parties negotiating agreements, because you have to crystal ball gaze to some extent as to what the circumstances may be like at the time of a future divorce. Obviously, that's much harder for couples starting out at the beginning of their marriage than it would be for older couples perhaps getting married for the second time, because you don't necessarily have as good an idea about the trajectory of their wealth and what they may plan to do going forward. So we always try and make sure that our agreements are as flexible as possible to take account of significant life events such as the birth of children, so that they don't have to be reviewed year on year and they stand the test of time.
That's really interesting to hear you say that, Dickon, because it sounds like there is a real process that needs to be followed and experienced to get nuptial agreements in place. And many families might think, that's just a massive faff and I might avoid it. So, what are the benefits of nuptial agreements for families, and to help them realize that there are significant values in them?
Yeah, I mean, as you say, they're pretty unromantic. It may seem like that, at least at the start, but they can provide certainty and avoid costly litigation for both parties in the event of a divorce. And also, in my experience, it'd be quite healthy to begin a marriage, having had a sort of healthy discussion about these sorts of issues. Where do they plan to live? If they have children, are they to have children? If they are to have children, will, for example, the wife carry on working? What expectations do they have as to the standards of living they will enjoy, and who is going to be funding it? And it's surprising the number of people you come across who haven't had those sorts of discussions actually before they make such a big commitment to somebody. So it's a good way of at least starting a dialogue as to those sorts of issues to ensure that everyone's on the same page from the outset. And in that sense, it sounds cheesy, but it sort of does support the marriage starting off on a healthy note. But practically speaking, we weren't surprised to hear that the vast majority of people who decide to have a prenuptial agreement, the driving force behind that is because usually one half of the couple has significantly more money than the other, or at least that they expect they will in the future because they may inherit or be due to inherit significant family wealth. So they approach it from an asset protection perspective, because I said it allows you to define which property is going to be shared, which you could say that any money which we build up during the course of the marriage will be shared, and usually equally, but you can define what proportions that would be. But significantly, you can define and ring fence which assets aren't to be shared. So that could be a family company, it could be a company that an entrepreneur has set up, or it could be a property which a parent has purchased for their child. And actually, I had a client recently whose family in Malaysia had helped them buy a property in London, where he'd been studying and then working, and then now met his now wife. And understandably, it wasn't that they didn't like her or didn't trust her, but they are just conscious that this is their hard-earned money, and they've worked very hard for many years to build up the money that they want to pass on to the next generation. And they were eager to ensure that they protect that as part of a wider package of sort of estate planning, wealth planning measures. And in that case, actually, it was relatively straightforward, because the wife-to-be had her own family money that her family were eager that she protected. It wasn't as significant, but it was still a sort of principal thing that we should each ring fence what we each brought into the marriage. But also, she was from America, and so they're very popular prenuptial agreements in America, and as such, there's less of a cultural taboo about being asked to enter in one, essentially. And we're certainly finding that in England as well, and with other jurisdictions we work with. As they become more commonplace, there's significantly less cultural taboo about, it's not intended as a slight if somebody suggests that you consider entering into one. So, as I say, they're becoming increasingly popular. As well as young couples, we also see people at the other end of the spectrum who are entering into prenuptial agreements because they're getting married for a second time. They may have gone through a costly, acrimonious divorce first time round, where they've lost a significant amount of their wealth. And they may therefore be eager to try and protect, ring fence a certain amount of capital in order that they have something to leave to their children from their first marriage, for example.
Just picking up, Dickon, on that example that you gave of the client, the one party was Malaysian and one American, that gives rise to thoughts about what Alfred was saying about next generations tending to be more internationally mobile, and therefore you end up with these transnational marriages. What are the international aspects that you think should be considered with nuptial agreements? Yeah,
I mean, as you say, what the driving force behind the international considerations is that courts in different jurisdictions take markedly different approaches to what constitutes a fair financial outcome on divorce. So London is stereotypically considered the divorce capital of the world, and that's largely because England takes a relatively generous approach towards financial division for the financially weaker spouse. So the starting point here, in very simple terms, is that there's a 50-50 division of capital. Doesn't matter who earns the money, because we consider here the breadwinner and the homemaker to have made an equal contribution. And similarly, historically, we've had very generous spousal maintenance terms that could potentially mean that someone is paying maintenance to their ex-wife for the rest of their lives. So understandably, people considering England as a potential place to get divorced, it's very attractive for the financially weaker party. It's less so for the financially stronger party. And so that's why nuptial agreements are increasingly popular here, particularly for those that do have wealth. And often clients think at the beginning of a case that where they're married or where they're domiciled will determine the law that applies in terms of the financial ramifications of divorce. But actually, it's obviously where you actually end up getting divorced that determines which rules will apply. In simple terms, the party can divorce in England if they've lived here for 6 months and are domiciled here, or 12 months and they're not domiciled here. So if one party has a connection to England, or there's a chance that they might move to England, it's advisable that they do enter into a nuptial agreement, whether it be a prenup or a postnup, or if they have signed a nuptial agreement in another country and they're considering moving to England, to check with an English family lawyer how the English courts might approach that agreement. Because as I mentioned previously, there are a number of different requirements here that would need to be met in order for the agreement to be considered valid from an English perspective. So if it's signed in another jurisdiction where there aren't the same requirements about taking legal advice and exchanging financial disclosure, it may be less likely to be upheld. So from a sort of perspective of reducing clients' exposure, it's definitely worth looking into. It's also significant that, as well as taking very different approaches to financial division on divorce, different jurisdictions take different approaches to to prenuptial and postnuptial agreements in general. As I say, the rule in England is if they meet these requirements, they're more likely to be upheld than not. And obviously, I practice solely under the law of England and Wales, but because of all these international elements, we do frequently work with lawyers in other jurisdictions in order to make sure that a nuptial agreement will be as enforceable as possible in whichever jurisdiction it is that is most likely that the parties will divorce in. So in terms of the different approaches, as I say, in Hong Kong, for example, I understand that they follow the same requirements as England in terms of the Radmacher Supreme Court case. In Malaysia, I understand that they're quite increasingly popular from the perspective of recording parties' intentions on divorce, but actually the statute stipulates that they can't actually be, they can't fetter the court's discretion, essentially. So the court will, has the ability just to totally ignore them, regardless of what's said. Whereas in mainland China, and some they are generally followed if they're sort of written down and recorded as the party's intention on divorce. So I suppose the takeaway is that if parties are married or planning to get married, or if they have children that are considering getting married, and there's a chance that it could be either with an English person or that they're going to be studying or working in England and therefore could end up divorcing here, it's really worth considering limiting their exposure by discussing the potential for a prenuptial or postnuptial agreement. And obviously we've got Q&A and we've got the networking afterwards, but if anyone has any questions afterwards about how it all works, do feel free to send me an email.
Thanks, Dick. And I think what's really interesting, one of the things that you said is that, for Patricia and I, we advise a lot of clients before they move to the UK on pre-residence tax advice and immigration. But it sounds like from what you're saying as well is that a large part of that is matrimonial planning as well. And making sure that any nuptial agreements in foreign jurisdictions are respected in the UK, or if they need to get English prenuptial agreements or postnuptial agreements. So that is the interesting point then. So as advisors in the audience to families or older generations who are wanting to encourage younger generations to enter into nuptial agreements, I mean, it's an incredibly sensitive topic. So do you have any handy tips that our guests can take away with them as to how people can approach raise the issues of nuptial agreements with younger generations?
Yeah, I mean, always find it's easier and well less hurtful, at least for the person who's being asked to enter into it, if you can sort of blame somebody else. So you can say my advisors told me this is a really good idea, or my lawyers advised it, or even my father said it's nothing personal, but it's a condition on me being given this inheritance that I enter into it.
Right.
And my siblings have been asked the same thing as well, so don't take it personally. But essentially, if the conversations can come as early on in the process as possible, and ideally directly between the parties, so that they can at least discuss the potential of having one, and ideally the sort of key principles that will apply, whether it's just about ring fencing family wealth, or whether there's going to be some other structure put in place. Because the risk otherwise is that you either leave it until the last minute, and therefore that doesn't allow for the sort of rational, calm conversations, which or a sort of properly negotiated outcome, which, as I said before, is more likely to lead to an agreement that's likely to be taken seriously by the court. But also the person doesn't feel like it's been sprung upon them if it's at the very last minute and there's all the pressure of the invitations having gone out, as I alluded to before. So if a conversation can have happened on the ground first, between the parties, on the sofa, around the kitchen table, where they can say, look, this is something that I'd like to enter into. I want you to be very happy with it. But before that comes, if you can agree some principles, so you don't just get a long, complicated, although we try and keep it as simple as possible, but a document inevitably with some legalese in it from one person's lawyer to the other, and it's a sort of something that makes them feel slightly ambushed. If that can be avoided, that's a really helpful practical tip in my experience.
So it sounds like lawyers are good for one thing, being blamed on, basically. So.
Yeah, absolutely. Yeah.
Thanks, Dickon. So I think we're entering into the last parts of our panel discussion, let's kind of finish off by shifting the focus onto the children of next generations. Patricia, I mean, you see a lot of this. What issues involving next generation children are you currently seeing in families in Asia focusing on, or anticipating will become more of an issue as time goes on?
Thanks, Alfred. Yeah, I can think of many, but just one that I'm going to highlight is one that I've seen cropping up quite a few times myself with families that we work with. And that's the issue of gender equality, whether sons should be treated the same as daughters or not. As I say, this does seem to come up quite a lot, and it can be quite a thorny issue. It has the potential to set maybe generation one on the one hand against 2 and 3 on the other, if it's not sort of caught and dealt with or addressed on time. Just to give one practical example, real life example of a family that we worked with. So we were advising them, helping them to create a family trust to hold the family business. And the set law made it very clear that he wanted daughters to receive smaller share of distributions than the sons, rather than an equal division. And of course, this would have meant that the daughters' respective family branches would then have gone on to receive less, even if the daughters themselves had had sons. So the siblings were not comfortable with this. They thought that there should have been equal division between them. And they had various discussions about it, including whether they would just even up between themselves. But that wasn't really considered to be very satisfactory because of the principle at stake as much as anything else. And so we were able to flag this as a potential source of conflict or a potential problem to the set law, so that he could understand that this could cause conflict between the siblings, potentially unnecessarily. And in the end, a compromise was achieved, so that the portions for division, rather than being put into the trust deed itself, where they, of course, would have been binding, they were put into the letter of wishes, which is obviously not binding. And then there was also a recognition by the set law that it would be possible for future generations to alter the letter of wishes. And I just think this example in particular does highlight a few really key principles of family governance planning, which is that often the answer will come down to compromise. So that really does require a lot of the ability for the family to have open dialogue with each other. And I think as part of that, as independent advisors and people standing outside the family, we're in the perfect position. By we, I mean be it the trusted advisors, so the lawyers, the trustees, the bankers who have the relationship. We're in the perfect position to start those conversations that the family may shy away from having between themselves. And we can be the moderators in that situation because we're not caught up in the family emotion. And then also the point that the family governance framework does need to be dynamic. It has to be flexible enough to adapt over time. Otherwise, it will just fall apart if it's so rigid that it doesn't cater for changes in the family circumstances in the future.
I mean, those are some really good points to highlight, and I think whilst we enter into this kind of the final parts of this discussion, what do you think are the kind of the key suggestions or tips that our audience today can take away with them for helping them to highlight or spot the issues when it comes to next generation children in Asia that they can advise their clients on?
For existing structures, I would say it's obviously really important to audit them regularly to consider whether there is any need to modernise or to adapt them. Right. One issue, for example, do they cater for all types of children? So traditionally, illegitimate issue are would probably not have been included within a class of beneficiaries, for example. And now, depending on where the structures have been created, the laws of that jurisdiction may automatically include illegitimates. I think Bermuda, for example, is one such jurisdiction. And so the family has to be comfortable with that. And the advisors have to make sure that the family understand, what that means. And for new structures, it's obviously important to look at all of these issues from the start. And the audit is also important to ensure that the family's particular circumstances are catered for more generally. I think it's a really good thing to have an annual meeting with the family members and the main trusted advisors to take stock, because it's always useful just to encourage everybody to look ahead. For example, what might be coming up in the lives of the family members over the next year or so. Are there any forthcoming marriages? Do we need to pick up the phone to Dickon and see if there has to be a conversation about prenuptial agreement? As Dickon mentioned, depending on where the parties are based, there might be specific requirements that have to be met for the prenup to be valid. So it's always preferable to plan these things in advance. And equally, as you were referring to, if there's a change of residence, if a family member is going to relocate, there might be specific advanced tax planning that should be looked at. And so, at the annual meeting, we'll just have to flush out all of these issues. And it's also really useful for keeping everyone engaged and giving the family members a forum to air their views, because that takes the potential frustration and maybe suspicion, if it's there, out of the picture, which immediately helps to reduce at least one potential sort of conflict.
Thanks, Patricia. I think we've kind of come to the end of our kind of panel discussion portion. I think we've got a few minutes now for us to take any questions from the audience, if there are any. I've seen there's one that's come in, which is an interesting one and a good question to raise. And I think it's mainly something for Patricia and I, but Dickon, feel free to chip in if you have any experience of this. But the question is, which jurisdictions for establishing trusts are preferred by Greater China clients? And are they aligned with your teams? And I think in terms of from what I've seen, is that for clients in the region, the typical jurisdictions tend to be Hong Kong and Singapore. So one's in the Asia region. But I've certainly seen where there are more globalized families. So family members in, say, for example, based in the UK, there is more of a greater acknowledgement for trusts to be established in the Channel Islands, for example. And for example, Jersey, where we're actually helping a Hong Kong family with two daughters in the UK, actually resettle trusts that are going to be administered and governed by Jersey law. So I think that is certainly a greater recognition for clients in the region that once they've got more international dimensions, they need to have more internationalized trusts. I mean, I don't know if you've seen anything similar or different, Patricia.
No, I totally concur, Alfred. And I think it's a sense of there being no one size fits. It very much depends on a case by case basis what the requirements of the family are, which would dictate which jurisdiction they might use. So it might be issues of perpetuity, something as simple as time zone, or provisions that they're able to build into the trust in one jurisdiction that may not be possible in another. So I think all of those factors come into play.
Yeah, I think that's a good point. I mean, there's no kind of one model or template that can be rolled out. I mean, each family will have very different kind of needs and factors and circumstances that will then determine where's the most appropriate for establishing their trusts. And I think with international issues, it just adds to the complexity and the need to consider all the issues in the round. So I don't know if there's any further questions that have come through at all. So I think we're probably kind of bringing to the end of our panel discussion. There's no further questions. I think we'll now be ending this Zoom webinar session. And for those of you who wish to join us for the networking session to say hello to familiar and new faces, please feel free to follow the second Zoom meeting details, which you can find in the confirmation email that you all received yesterday and this morning. So thank you very much.